We are delving into the crucial topic of patenting the impossible, that complex space where natural law meets protected technology. Our discussion today focuses squarely on the challenges inventors face when trying to secure intellectual property rights for new methods of geophysical prediction. This strategic guide will walk you through the specifics of 35 USC Section 101, ensuring you have the necessary tools to effectively protect your cutting-edge algorithms and innovations. Albert Einstein, the quintessential physicist, understood the crucial difference between a fundamental law of nature and a patentable invention. While E equals mc squared was an unpatentable discovery, he secured dozens of patents for tangible devices, like this refrigerator designed with no moving parts. The system rewards the specific application of a scientific principle to create a new, useful machine, not the principle itself. This focus on practical application, not just theory, is the foundational mindset for successful technological prediction and patenting. Our work relies on understanding nature through fundamental scientific principles, but patent law strictly excludes three categorical exceptions: laws of nature, natural phenomena, and abstract ideas. This creates the innovator's paradox. For example, a claim simply predicting an earthquake by analyzing seismic data and applying a known physical formula will be rejected outright under 35 USC Section 101. Given these prohibitions, we must determine how to structure our valuable innovations for proper legal protection. The Supreme Court, through the Mayo and Alice decisions, gave us the essential two-step blueprint for bridging a fundamental law of nature and a patentable invention. Step 1 asks if the claims are directed merely toward a patent-ineligible concept, like an abstract idea. If they are, Step 2 becomes crucial. We must identify if the claim includes a genuinely inventive concept. This vital second step is what transforms that ineligible idea into a truly eligible, patentable application. The core challenge in patent eligibility is proving your invention is not merely an abstract law of nature. The inventive concept acts as the essential keystone, bridging this gap to a patentable invention. We must demonstrate something significantly more, an application that is non-routine, non-conventional, and improves an existing process. Consider the diamond versus deer precedent. The patent was valid because they used specialized hardware to dynamically recalculate the rubber curing time, transforming a scientific principle into a genuine industrial improvement. Patent eligibility hinges on demonstrating a specific, unconventional technological method, not just claiming an abstract result. We see two main paths: improving the technology itself, like in Amdoc's data flow solution, or using unconventional components, such as the unique sensor arrangement in Thales. The courts are clearly focused on whether the claim describes a concrete implementation that truly solves a technical problem and improves the actual machine or process.
Let's examine a typical geophysical claim focused on earthquake prediction. When we analyze this hypothetical method, receiving seismic data, applying the physical law of rock mechanics, and displaying the result, it runs into immediate trouble. The PTO views the core of the claim as merely monopolizing a known law of nature. Since the steps of collecting data and generating a display are conventional activities on a generic computer, the entire package lacks the necessary inventive concept and is deemed patent ineligible.
We successfully revised the claim by embedding specific technological solutions. Crucially, the system now integrates unconventional subterranean sensors and a novel filtering algorithm that dramatically improves signal clarity. This advanced data then feeds into a process that automatically adjusts regional utility grid controllers, shunting power away from high-risk substations. By protecting this specific integrated technological application, not the underlying physics, the claim is now clearly patent eligible. Transforming an abstract idea into a truly patentable concept requires shifting our focus from the what to the how. This means integrating tangible, unconventional applications. We look for either truly novel hardware, like unique sensor arrangements, or specific algorithmic improvements that fundamentally boost computer performance. The invention must also engage with the real world, either by integrating with physical systems to cause tangible action, or by effectively solving a very specific technical problem within its operating field.
The specification is your absolute foundation for withstanding Section 101 scrutiny. Your application must meticulously detail the technological improvement, never assuming that novelty is obvious. To ensure compliance, you must explicitly state how the invention improves the prior art, why it's more than just typical computerization, the specific technical problem being solved, and finally, the intricate details of your unique inventive concept, explaining exactly how that novel structure or algorithm functions. A Section 101 rejection is simply the beginning of the negotiation process. Your immediate action should be contacting the examiner. This is often the fastest route to clarity. Following that conversation, you have 3 primary response strategies. First, argue your claim directly addresses a technological improvement. Second, demonstrate the invention contains significantly more limitations, like novel hardware. The most common path, however, is to amend the claims to add specificity, transforming the abstract idea into a concrete, patentable implementation. The core takeaway here is simple. You cannot patent the underlying physics or the seismic wave itself. The road to protection lies in building a better tool. Your true invention is not the theoretical equation, it is the novel sensor that gathers data, the efficient algorithm that processes it in a new way, or the integrated system that turns a scientific prediction into a protective action. Focus your patent energy on engineering that tangible technological solution.
We often believe that true innovation must start from scratch, but today we challenge that assumption. Our discussion centers on the resurrection myth, a strategic approach to mining the vast wealth of knowledge contained within expired patents. We will explore exactly how smart organizations are now unlocking dormant inventions and successfully building powerful new technologies by strategically leveraging the public domain as their foundation for future growth.
The question we often face is whether we can resurrect an expired patent. The short answer is emphatically no. Expiration is final. Many believe that maintenance fees or legal maneuvers can extend protection, but once a patent expires, its claims immediately enter the public domain. This permanent entry is a fundamental feature of the intellectual property system, designed specifically to foster subsequent innovation and allow creators to build upon existing knowledge freely.
The public domain is a powerful foundation, not a graveyard for old ideas. Think of expired patents as detailed, free roadmaps to proven technologies, providing immediate starting points that significantly de-risk your R&D investment. Our strategy must be proactive. We improve, combine, or find new applications for these public resources, often generating entirely new, patentable intellectual property in the process. Building your innovation foundation starts with accurately defining your invention, avoiding generic terms, and classifying it using the Cooperative Patent Classification System. After verifying those CPC codes, use them in databases like PubEast and Espacent to retrieve both active and expired patents efficiently. Crucially, don't stop there. Broaden your scope to include non-patent literature, such as journals and technical catalogs, to ensure you have a truly comprehensive view of the entire prior art landscape. The pharmaceutical industry is staring directly at the patent cliff, visualized here as a massive wave approaching between 2025 and 2029. Blockbusters like Eylea and Eliquis begin the descent, but the real impact arrives in 2028 with Keytruda and Opdivo. While patent expiry opens the floodgates for generics and biosimilars, this seismic shift also creates vast opportunities. We must proactively drive next-generation innovation, focused on new formulations or proprietary combination therapies, to successfully ride this wave.
Any invention that builds upon existing concepts must successfully pass the critical Alice-Mayo test. The Supreme Court is firm that you cannot patent the basic tools of science, like laws of nature or abstract ideas, as these are the building blocks of human ingenuity. Therefore, merely discovering a natural correlation or implementing a long-standing abstract concept on a generic computer is not sufficient for patent eligibility.
Our patent eligibility analysis utilizes a clear 2-step framework. First, we must ask if the claim is simply directed toward an abstract idea, a natural law, or a natural phenomenon. If it is, we then proceed to step 2. This second crucial step asks whether the individual and combined claim elements provide an inventive concept. The claims must demonstrate something significantly more than the ineligible concept itself, transforming the abstract idea into a true, eligible invention. The Ariosa dilemma teaches us that a brilliant discovery isn't always an invention. While finding cell-free fetal DNA was groundbreaking, the initial patent was invalidated because it simply combined a natural phenomenon with conventional lab techniques. True patentability arrived later with the Illumina case, which introduced an inventive application, exploiting the unconventional insight that fetal DNA is shorter than maternal DNA to create a new, separable process. Therefore, the patent is not for the discovery itself, but for the unconventional, inventive application that follows. A powerful wave of foundational digital patents is rapidly entering the public domain. For example, Apple's original multi-touch patent expires in 2026, followed shortly by key video compression standards like H.264 by 2030. This seismic shift eliminates friction around the core building blocks of the digital economy. The massive opportunity is the ability to develop new hardware, software interfaces, and media services without the burden of costly, complex licensing. We are fundamentally shifting our perspective on intellectual property. Instead of treating our patents like a fortress, walled off and fiercely defended, we are moving towards an ecosystem model. This strategic move, exemplified by Tesla's open pledge, involves deliberately placing technology into a shared commons. The goal is clear: accelerate the entire industry, encouraging rapid, follow-on innovation and growing the total market, rather than simply defending one company's small slice of it. Tesla's patent pledge is fundamentally a pact, not a free-for-all. While participants can utilize our patent commons free of charge, access is conditional on maintaining good faith. This means parties cannot assert IP against Tesla or other ecosystem participants, challenge our patents, or market knockoff products. Essentially, we've created a defensive patent ecosystem where companies gain access to our technology in return for agreeing not to use their own IP offensively within this shared space. Tesla's innovation pace has clearly accelerated since the 2014 pledge, demonstrated by our robust patenting efforts and near 90% grant rate. This momentum stems from our focus on next-generation IP, creating a powerful innovation cycle. We are simultaneously advancing material science for gigacasting, revolutionizing battery tech with the tabless 4680 cell, deploying the radical unboxed manufacturing process, and developing custom AI and silicon for true autonomous driving. An effective IP strategy requires moving from defense to reinvention. We must first reframe expired patents as strategic R&D assets, proven, de-risked starting points. Systematically mine the literature to find foundational technologies and de-risk your own innovation. Critically, patenting today is about creating a specific, non-obvious application that passes modern legal tests. Ultimately, ask if your strategy is a defensive fortress or if it actively builds a broader, cooperative market ecosystem. To truly master this topic, continue your exploration with these essential resources. For technical searching, utilize the USPTO tools and the expansive European S-Passinet database. Understanding the legal landscape requires reviewing landmark Supreme Court precedents, especially Alice Corp and Mayo Collaborative, which define patent eligibility today. For real-world context, explore unique case studies like Tesla's famous patent pledge and ongoing research from the Duke University Public Domain Center. Every groundbreaking invention starts with an observation about the fundamental truths of the natural world. But how do we bridge that gap, from cosmic observation and natural law to a precise, patentable blueprint? We need a clear guide. Over the next hour, we'll be using the Inventor's Compass framework, which is designed specifically to translate those foundational scientific principles directly into tangible, commercially viable breakthroughs. Every significant breakthrough exists across two distinct realms. It begins with the discovery of natural law, the fundamental abstract principles, like the law of gravity or the structure of DNA, that are unpatentable in themselves. The real commercial impact emerges in the world of applied invention. This is the realm of ingenious creation, where we transform those abstract truths into concrete applications, whether that means designing a jet engine based on aerodynamics or engineering specialized bacteria to solve an environmental challenge. We visualize the patent system as a bridge, the inventive concept. This structure must successfully span the distance between the abstract world of natural law and the tangible world of applied invention. The patent system protects this critical span, but its structural integrity absolutely depends on 4 essential legal pillars. We must verify eligibility and novelty, confirm the design is non-obvious, and ensure the blueprints, the claims, are clearly enabled and defined. Albert Einstein, the practical inventor, partnered with Leo Szilard to create a safer refrigerator free of failure-prone mechanical seals. Their innovative electromagnetic pump is the perfect example of bridging theory and application. By using an alternating current to create a moving magnetic field, they propel a liquid potassium-sodium alloy, which acts as a silent, sealless piston to compress the refrigerant. This seamless mechanism highlights reliability through simplicity, eliminating the need for any complex, moving mechanical components. Tesla faced a critical challenge. High-quality gigacasting requires premium aluminum, but scrap metal is often contaminated with iron and zinc, making it unsuitable for safety parts. Their proprietary scrap alchemy is the inventive bridge. This patented novel process specifically counteracts those impurities, enabling them to use cheaper, low-grade scrap that competitors cannot touch. The result is the sustainable production of massive single-piece vehicle frames at a fraction of the cost, slashing reliance on expensive virgin materials. American Axle attempted to patent a crucial method for manufacturing prop shafts that simultaneously dampens 2 vibrations by tuning a liner inside the shaft. However, the court found this claim relied entirely on fundamental physics, specifically Hooke's law, making it ineligible. The patent did not describe how to achieve the desired result. It only directed others to apply known law via trial and error. As the court stated, it tells you to do tuning, but it completely fails to tell you how to do the tuning. The Alice-Mayo test provides our crucial 2-step checklist for patent eligibility. First, we determine if the concept is directed toward a fundamental law of nature. It's important to remember that most great inventions begin here, and that is completely acceptable. The real challenge is step 2. Have you engineered a concrete bridge? This requires applying that natural law in a non-routine, unconventional way, creating an inventive concept that transforms the application into something significantly more. Sakita creaming, like using methods of treatment, is often key to success here.
Securing your invention demands we focus on the how, not just the desired what. Result-oriented claims, like the example of tuning a liner to reduce vibration, describe the goal but lack the necessary detail. Successful claims, however, are method-oriented, detailing the specific structure or steps, the complete blueprint as shown here. Ultimately, the invention is the specific machine or process you build, not just the function you achieve.
Design patents hinge on the 2 worlds principle, distinguishing appearance from mere utility. We cannot claim a natural form, like the shape of a seashell, as it is not inherently original. Instead, the design must fall into world 2, an inventive design, which is the conscious act of the inventor. The core takeaway, established in re Carletti, is that for a design to be patentable, it must be created specifically for the purpose of ornamenting the article in which it is embodied. Protecting your invention starts with scouting the landscape of prior art. It must be novel and non-obvious. We begin with brainstorming keywords, then use those terms to find the cooperative patent classification or CPC codes necessary for a focused search. After reviewing patents within those specific classes, we must always go beyond technical documents and check non-patent literature like academic journals. This comprehensive process validates novelty and provides crucial context for framing your strongest patent claims. A patent is a public contract where you trade full disclosure for a limited monopoly. This requires technical precision in two key areas. First, enablement means your specification must be a functional how-to guide, allowing a skilled person to build it without undue experimentation. Second, definiteness ensures your claims act as clear property lines, defining the precise scope of your intellectual asset. Your application is strictly a technical blueprint, not a marketing document, making completeness and clarity paramount for its validity.
The core challenge in patent drafting is moving beyond obvious principles like Hooke's law. To create a stronger, more defensible claim, a better bridge, we must introduce specificity. This means detailing the multi-step manufacturing process, claiming the unique geometric structure or alloy composition, or specifying the enabling technology, like proprietary FEA models used for design. Ultimately, we must transform those abstract goals into concrete specified inventions.
Every inventor faces a critical strategic choice: the toll road or the open bridge. While traditional patents grant us the right to exclude others, fiercely protecting IP can sometimes limit overall market acceleration. Tesla made the deliberate choice to pledge its core EV patents, not out of altruism, but to encourage rapid ecosystem creation and standardization. By opening up their technology, they grow the entire market, ultimately trading short-term exclusion for long-term ecosystem dominance.
The path from scientific theory to marketable innovation requires a clear compass. We start in the world of natural law, mastering the foundational principles. Our goal was to build a bridge with an inventive concept, focusing on the how, the specific, tangible application. We must then stress test this design using the 4 pillars: eligibility, novelty, non-obviousness, and enablement. True invention is translation, converting a timeless principle into a timely, defensible, and impactful solution. Our discussion of eligibility begins with the landmark 2014 Supreme Court decision, Alice Corp v. CLS Bank International. Often referred to as the gatekeeper, this unanimous ruling fundamentally redefined the boundary under Section 101. It established a rigorous 2-part test to separate truly patent-eligible inventions from simple, abstract ideas merely implemented on a generic computer. This ruling remains the central challenge for software and business method patents across all sectors today. The central question was whether a generic computer-implemented escrow system could be patented. The Supreme Court unanimously ruled no, holding the claims invalid because they were directed only to an abstract idea without an inventive concept. This established the core rule: generic computer implementation alone does not grant patent eligibility. Most importantly, this ruling gave us the definitive Alice-Mayo 2-step framework, now used by the USPTO and federal courts to determine subject matter eligibility. Our statutory foundation, 35 U.S.C. Section 101, establishes a wide gate, making almost any new and useful process or machine eligible for patent protection. Yet the courts have imposed 3 critical judicial exceptions, barring patents on laws of nature, natural phenomena, and abstract ideas. This serves a crucial policy goal: preempting preemption. Monopolizing these fundamental tools of scientific work would severely impede innovation rather than promoting it, undermining the entire system. We've spent significant time analyzing our history, understanding what worked and what didn't. But history isn't just a record, it's the foundation for what comes next. That complex analysis, that deep learning, is simply the prologue. Now, with the blueprints laid out, the real work begins. We need to take these insights, illuminate the path forward, and immediately begin constructing the innovative solutions we discussed. We are here to build the future, starting today. The patent journey begins long before filing, ensuring your idea is truly novel. We use the foundational 7-step U.S. patent search strategy provided by the USPTO to navigate prior art. This methodical process systematically moves from brainstorming terms and searching CPC classifications to reviewing published documents and expanding the search to non-patent literature. This diligent preparation builds the foundation for success, but once filed, your invention must face the ultimate test, the eligibility gauntlet.
The patent eligibility process is fundamentally a gauntlet designed to prevent monopolizing the basic tools of science, as mandated by 35 U.S.C. 101. The real challenge lies in avoiding the three core judicial exceptions: laws of nature, natural phenomena, and abstract ideas. As the flowchart shows, if a claim touches one of these, it must possess an additional, significant inventive concept. Without that inventive step, the claim is immediately ineligible, regardless of its novelty.
The legal prohibition against patenting natural laws is not arbitrary. It's a long-held legal principle designed explicitly to protect the very building blocks of innovation. The Supreme Court has consistently affirmed that foundational discoveries, like the qualities of bacteria or basic laws of nature, must remain freely accessible to all. As echoed in Mayo v. Prometheus, if there is to be invention, it must come from the application of that principle in a new, inventive way. The gauntlet's purpose is to enforce that critical distinction between discovery and true inventive application. We begin the eligibility gauntlet with Gate 1, the essential threshold inquiry based on the statutory language of 35 U.S.C. 101. The examiner asks, does the claim describe a process, machine, manufacture, or composition of matter? If the answer is no, eligibility fails immediately. If it's yes, we advance to Step 2A. For nearly all modern technological, software, and life science applications, this initial hurdle is easily cleared. The true complexity in patent eligibility will arise in the subsequent stages.
We are now at Gate 2, the most critical and nuanced stage of eligibility analysis. Is the claim directed to an exception? The USPTO uses a two-prong inquiry here. First, does the claim recite an abstract idea or law of nature? If not, we are eligible immediately. If yes, we proceed to prong 2. Do the additional elements integrate that exception into a practical application? Only if the answer is yes here are we eligible. Otherwise, the claim fails this state and proceeds to Step 2B.
We need to move beyond merely stating a natural law and ensure our claim integrates into a practical application, effectively turning the abstract into the concrete. This requires the additional claim elements to impose a meaningful limit. Examiners are specifically looking for indications like improvements to technology, the use of a particular machine, or the physical transformation of an article. Crucially, the question of whether these elements are routine or conventional is not a factor here. That critical assessment is strictly reserved for Step 2B. This case study from USPTO guidance clearly defines the eligibility line. Claim 1 simply calculates the curing percentage using the Arrhenius equation, failing Step 2A because it's merely abstract data gathering. Claim 4 succeeds because it integrates the equation into a real-world feedback loop. By using the comparison process to send a control signal directly back to selectively heat or cool the injection mold apparatus, it establishes the necessary practical application for eligibility.
We examined denveric acid, a naturally occurring protein that aids diabetics. The initial claim, simply packaging the acid in a container, was deemed ineligible as a basic product of nature with no inventive concept beyond merely applying it. Crucially, the path to eligibility lies in altering its function. By mixing denveric acid with protamine, we create a new composition where the glycemic control is significantly more long-lasting. This demonstrable change in function establishes a markedly different characteristic, making the new composition claimable.
If the claim recites a judicial exception, we proceed to Step 2B, the final eligibility gate, the search for an inventive concept. We ask, does the claim as a whole amount to significantly more than the exception itself? This means looking for elements that represent a specific, unconventional limitation, something truly not routine or well understood in the field. Simply appending conventional activities is insufficient. However, this is also where previously minor steps, like unconventional data handling, can now provide the critical inventive concept.
Sauce inventions are a key battleground, as abstract ideas like generic load balancing or authentication concepts are often insufficient for success. To successfully navigate this gauntlet, you must demonstrate serious technical depth. detail the unique algorithms, the data flow processes, or proprietary API structures that enable seamless integration. Always frame your innovation as a concrete technical solution that achieves a tangible, measurable result, such as improved prediction accuracy or faster data categorization. The complexity of Section 101 eligibility remains a central challenge, with rejection rates remaining consistently high, especially in the business method and software fields. Recognizing this difficulty, the USPTO initiated the DSMER pilot program. This program streamlines prosecution by allowing applicants to defer responses to Section 101 rejections until clarity is reached on other issues, like novelty or obviousness. This represents a significant step toward exploring more efficient examination strategies. Successfully navigating the gauntlet requires tactical precision. We need to frame our inventions as concrete technological solutions, detailing the technical means, not just the abstract idea. Crucially, integration must be deep, not a mere application, and we must demonstrate robust technical depth using detailed specifications and flowcharts. The final principle is simple. Always include elements that add significantly more than the conventional approach to truly establish the inventive concept.
We often think of Albert Einstein purely in theoretical terms, but the journey from E=mc² to a patentable self-adjusting camera perfectly illustrates the history of innovation. Einstein was a prolific inventor, holding over 50 patents, including designs for an absorption refrigerator and even a blouse. His work shows that the patent system rewards the crucial step of transforming fundamental scientific truths, whether a law of physics or a natural phenomenon, into tangible, world-changing inventions.
Welcome. This report delves into the state of innovation, providing our crucial outlook for 2025 and 2026. Global intellectual property is rapidly evolving, so we conducted a comprehensive macro analysis utilizing recent USPTO data and broader market intelligence. Over the next hour, we will specifically examine shifts in patent volumes, track key assignee leadership, and explore the major changes impacting the legal IP landscape worldwide.
Innovation has decisively pivoted from physical hardware toward pure intelligence. Patent volumes have stabilized, shifting the focus squarely onto quality and strategic filings, which has fundamentally changed the global hierarchy. Samsung is now leading, reflecting the dominance of Asian markets. AI and computer systems are rapidly displacing traditional sectors, with semiconductors remaining the core technology. Crucially, we must prepare for the 2026 horizon, where the expiration of foundational 2006-era smartphone and cloud patents signals a massive impending wealth transfer.
The American innovation engine is running consistently, delivering a total volume of 348,774 grants this year, with a strong 89% grant rate for high-tech filings. While the volume is high, we must focus on the average 16-month pendency until the first office action. This delay is a critical risk factor. It reinforces the urgent need for clients to move aggressively on early filing, ensuring they immediately secure priority within our first-to-file system. The United States is holding strong domestically, granting over 162,000 patents last year, an 18% jump. Yet, the primary external drivers of this growth are clearly shifting east. While Japan remains a leader, the combined velocity of China and South Korea represents the most significant competitive pressure on Western IP portfolios today. This rapid collective acceleration from two key Asian markets is a trend we must proactively monitor as we plan future innovation strategies.
The traditional hierarchy of assignment has been completely upended among the Big Five. Samsung Electronics now holds a commanding lead, securing over 10,000 grants, a massive statistical moat creating a 6,000-plus patent gap over the nearest competitor, IBM. Crucially, this reflects a strategic shift. IBM has moved away from volume-based leadership, intentionally narrowing their focus to acquire only the highest value, mission-critical intellectual property assets. The biggest trend shaping big tech portfolios right now is the total realignment around core AI infrastructure. You can see this clearly. Google is leading the pack with 365 dedicated AI applications, while Microsoft has over 200, and Apple is growing rapidly with 65. These firms are moving beyond simple software and deeply integrating machine learning models, neural network training, and visual recognition capabilities across every division, from core services to emerging VR/AR platforms.
Focusing on patent bandwidth, it's clear that the sheer volume of innovation is dominated by semiconductors, led largely by Samsung and TSMC. Close behind is virtual reality, though the fastest growing subsector is certainly AI and machine learning. Keep an eye on the future watch codes. We project that physical AI, or robotics, and non-rare earth motors will define the next major patent wave.
Tesla's intellectual property confirms its transition into an AI and robotics company. Of their 4,225 patent assets, 40% are now focused on computer systems, far outpacing the 9.8% dedicated to core automotive areas. Despite the 2015 patent pledge, filing growth significantly accelerated. This IP portfolio provides a strong defensive moat, actively cited thousands of times to reject competitive claims from rivals, including Ford, LG, and Samsung. The true geopolitical advantage lies in ushering in the iron age of EV propulsion, freeing us from rare earth dependency. This relies on zero rare earth magnet-free motors, utilizing a modified iron crystal structure to bypass the neodymium supply chain entirely. Coupled with the modular unboxed production architecture and next-gen battery chemistry like iron-air, this strategic technological shift offers immense potential for secure, scalable, and localized deployment globally. We are seeing crucial stabilization in Section 101 eligibility under the new USPTO leadership. While the three-step Alice-Mayo test remains the standard framework for evaluating claims, Director Squires has shifted focus toward applied technologies. This paves the way for greater protection in cutting-edge fields like distributed ledgers and medical diagnostics. This new emphasis is clearly working. We have witnessed a significant 44% decrease in eligibility uncertainty since the 2019 guidance was implemented. The P-tab is proving to be a highly effective filter. 70% of inter-parties reviews result in all challenged claims being invalidated, with another 15% seeing partial invalidation, meaning claims are fully upheld in only 15% of cases. The drivers behind this action are the giants we call the executioners. Samsung, Apple, Google, Intel, and Microsoft are the top petitioners, accounting for 81% of all major filings, as they strategically utilize IPR to neutralize litigation threats. Let's look ahead to 2026, when the patents filed during the massive 2006 surge finally expire. We call this the Class of 2006, and its expiration will significantly shake up the tech landscape. Assets from Microsoft's foundational Xbox Live and Qualcomm's early LTE and push notification connectivity standards are among those entering the public domain. The impact is profound. Foundational cloud architecture and mobile interface standards, the building blocks of modern digital life, become completely free for public use, encouraging new competition and innovation. We are looking ahead to Public Domain Day 2026, which will liberate incredible cultural staples from the 1930s. Imagine having free access to foundational stories like The Maltese Falcon and All Quiet on the Western Front, alongside beloved classics like The Little Engine That Could. This is a massive opportunity, as these works become entirely free for adaptation, creative remixing, and training our AI models without incurring expensive licensing fees. Looking ahead to 2026, three foundational trends are converging. Biomanufacturing is scaling rapidly through cell-free protein production systems. Simultaneously, the energy sector is moving beyond lithium toward metal air and sodium-ion batteries for next-gen solutions. These advances, alongside the integration of large language models into physical AI, like humanoid robotics, highlight a crucial common factor: AI supercomputers. They will drive the simulation capacity needed to invent the new materials required for success across all three areas. Our methodology provides a high degree of confidence by blending primary and secondary sources. We relied heavily on official data from the USPTO and WIPO, complemented by specialized legal intelligence from major law firms and industry analysis platforms like IP Watchdog. Furthermore, we integrated corporate 10K filings from key innovators like Tesla and Samsung, grounding our strategic landscape projections firmly in late 2025 data. This conflict centers on digital escrow and the $5 trillion question of mitigating global settlement risk. The patented mechanism, owned by Alice Corp, involves a third-party intermediary computer system managing shadow records between two obligated parties. However, the validity of this Australian patent is being aggressively challenged by CLS Bank. As a New York entity operating a major global settlement network, CLS is seeking a declaratory judgment to invalidate the entire technology. This timeline clearly illustrates the chaos driving this case to the Supreme Court. In 2011, the patents were invalidated as abstract ideas, but the Federal Circuit panel immediately reversed that decision in 2012. The true fracture occurred when the full Federal Circuit took up the case in 2013. A 10-judge panel issued 7 distinct opinions, failing entirely to agree on a legal standard. This deep internal division and subsequent legal chaos made Supreme Court intervention absolutely necessary.
This unanimous opinion, delivered by Justice Thomas, established a critical limit on abstract patents. The court stated clearly, stating an abstract idea while adding the words "apply it" is not enough for patent eligibility. This wasn't merely a theoretical warning. The decision immediately affirmed the invalidity of Alice Corp's patents. Moving forward, the industry must be highly cognizant that the court will prevent clever draftsman's art from circumventing Section 101. The core framework for eligibility is the Alice-Mayo two-step test. We first assess if the claim is merely directed toward a foundational legal exception, like an abstract idea or a natural law. If not, the claim is patent eligible. If it is, however, we move immediately to the crucial step 2. Does the claim contain a sufficient inventive concept? We look for elements that amount to significantly more than the ineligible concept itself. A lack of that inventive concept means the claim is unfortunately ineligible, as seen in the Alice decision.
In Bilski, the Supreme Court established that the concept of risk hedging is a fundamental economic practice and therefore an abstract idea. 4 years later, the Alice case confirmed this principle, ruling that intermediated settlement, using a third party to mitigate risk, is similarly a core economic building block. Ultimately, both hedging and intermediated settlement are deemed abstract ideas, meaning these claims successfully satisfy the first step of our eligibility analysis.
For step 2, we ask if the claim truly adds significantly more than just abstract instructions. Consider this server configuration: standard data processing, communication, and storage units. The components, though configured uniquely, are purely functional and generic. The court ruling confirmed that these elements did not improve the actual functioning of the computer itself, nor did they provide an improvement in any other technology. Without that inventive lift, merely combining known components to perform their standard function is not enough to secure a patent.
This case highlights the core principle that substance trumps form. Alice tried to employ the draftsman's art, arguing that her system claims, written as hardware, should be eligible, even when the identical method claims describing the process were not. The court firmly rejected this tactic. Their ruling clarified that eligibility depends solely on the underlying inventive concept, concluding that clever phrasing does not magically create patentable subject matter.
The danger of preemption lies in granting a patent monopoly over a basic building block of human ingenuity. Visualize this core brick. It represents a foundational, abstract idea like intermediated settlement. If we grant Alice's patent, we preempt the use of this fundamental concept across all fields, effectively granting a monopoly over an abstraction and undermining the entire structure of future innovation built upon it. The post-Alice landscape represents a dramatic recalibration of patent eligibility. The data clearly shows roughly 75% of challenged patents under Section 101 have been invalidated since the ruling. Initially, this massive surge targeted business method patents, but the impact quickly spread to areas like diagnostics, evidenced by cases such as Ariosa versus Sequinome. This outcome demands a fundamental and necessary shift in how we approach software patent strategy today.
Let's look at the current USPTO guidance for surviving Alice. The key is ensuring your abstract idea is always successfully integrated into a practical application. We need to filter that concept through concrete elements, like genuine improvements to computer technology, defining a specific machine, or treating a disease. If we demonstrate this integration effectively, MPEP 2106 confirms that the claim is not directed to the abstract idea, leading us directly to eligibility.
The dividing line under Section 101 rests squarely on whether the claim moves beyond the abstract idea. Generic concepts like managing financial transactions, analyzing data without technical improvements, or running mathematical formulas on basic hardware are likely ineligible. However, eligibility is granted for specific technical solutions. This includes specific improvements to computer memory, network-specific rules solving real technical problems, or detailed protocols for complex tasks like lip-syncing 3D animation. The focus must always be on a demonstrable technical advancement.
The enduring legacy of the Alice decision lies in maintaining a delicate balance. While we must incentivize inventors with protection for their new concepts, we must equally safeguard the basic tools of science and discovery. This ruling acts as the definitive barrier for software and business method patents. It ensures that genuine innovation requires a specific, practical, and inventive application, moving beyond the simple monopolization of abstract ideas.